Okay, so let's get into it. Today we're diving into a really focused topic, accountability in elder care.
Hmm.
And we're going to do that by looking at a specific case result from the legal group Bedsore.law.
And it's such a crucial area. I mean, these cases often pull back the curtain on some really deep systemic problems in the care system.
Absolutely. So our mission here is to quickly unpack the details of this pretty significant $450,000 wrongful death settlement.
Right.
But the thing that makes this one so interesting, what we really need to figure out, is that it was all resolved before it even got near a courtroom.
That's the tell. That pre-litigation settlement, it just screams that the evidence was overwhelming.
It has to be, right? The
Yeah.
facility's own records must have been, well, completely damning.
Exactly.
Okay, so let's start with the facts. We're talking about a resident in a Northern California facility. We'll just call her Gladys.
Okay.
She's there for about a year. And the details of her time there are they're shocking. The documentation shows a pattern of neglect, actual assault, and mental torment.
It's horrifying to even think about. But, that's just the background. The tragic part is that Gladys died under what were called mysterious circumstances.
And then came the critical medical finding.
Yeah. After she passed, it was discovered that she had developed a stage 4 bedsore. A severe one.
A stage 4.
Yep.
And just so everyone's clear, that is a catastrophic injury. We're not talking about a simple skin issue.
No, not at all.
That means the tissue is gone. You're looking at exposed bone or muscle. Something like that takes months and months of just sustained, absolute neglect to develop.
It's medically indisputable. A stage 4 injury is like a smoking gun for long-term failure of care. But there was a second piece here that just blew the whole case open.
The concealment.
The concealment. That stage 4 injury had been deliberately and entirely hidden from her family.
And that's where you see it cross the line, right?
Yeah.
It goes from simple, horrible negligence to an institutional failure.
Yes.
The source material we have says the facility and its owners were, chronically understaffed and underfunded.
And when that happens, the incentive just flips. It's no longer about fixing bad care. It's about hiding the results of that bad care.
So the defense is suddenly facing a claim, not just of neglect, but of an institutional cover-up. A cover-up designed to hide the fact that they weren't spending the money to staff the place properly.
That's the engine of the whole claim. And that intentional cover-up, that dramatically increases the risk of punitive damages if you let a jury see it. It's a huge liability.
So let's talk about the outcome. You have this combination of documented torment, a catastrophic stage 4 injury, and an active cover-up.
An explosive combination.
So Bedsore.law steps in and secures that $450,000 settlement. And again, the money is paid before a lawsuit is even filed.
Yeah.
That just shows you the incredible pressure those facts created.
Oh, it speaks volumes. It tells you the facility knew exactly what was sitting in their own files. They knew a legal discovery process would just unearth more and more damning evidence.
So they basically bought silence.
They bought silence and a quick resolution. It was damage control.
And you see this pattern in the work Bedsore.law focuses on. It's often bedsores, pressure injuries, and these awful fall injuries. They're sort of the clearest signs that a facility is chronically understaffed.
Mm-hmm. And I think for you, the listener, this case really illustrates a clear path to accountability. It shows how the system has to respond when you have severe, verifiable neglect.
Like the assault and that awful bedsore.
You pair it with clear evidence of a deliberate systemic cover-up. That creates immediate, overwhelming legal leverage.
So I guess here's the final thought I want to leave you with. If the facts were so strong that a facility paid out $450,000 without a fight, before the legal process even really began.
Yeah.
Just think about what that implies. What kind of internal memos, what staff communications, what other evidence must have existed that they were so desperate to ensure never saw the light of day? Something to consider when you think about the real price of an institutional cover-up.